right, guys, what's happening? Levi Trumbull reporting here, and stay tuned. We have an unbelievable victory as it relates to free speech and the First Amendment here in the state of Maryland. Guys, this is just totally awesome, and you're not going to want to miss a second of this video. We have wonderful news to share with you guys today, so with that, let's just dive right in. So if you have been following this channel, you know that recently we have been covering a dilemma involving First Amendment activist Shaun Porter within the confines of the Washington County government. If you're not familiar with the situation, we will briefly recap. So Mr. Porter was banned from the Washington County government building back in April of this year as it relates to offensive conduct that the Washington County commissioners claim he exhibited during his 3 minutes of public comment time. So as you guys are probably familiar with, he was using profanity, he was mooning the county commissioners, and they had gotten to a point where they were sick and tired of Mr. Porter redressing his grievances in the way that he was doing. So the county attorney issued him a letter of no trespassing on April 8th, 2025, which advised Mr. Porter that he was banned for 6 months from attending Washington County Board of County Commissioners public meetings. The letter actually cited that Mr. Porter's disruptive and offensive conduct was the reason that he was being banned from participating in these meetings for that 6-month period. So obviously, when this channel learned of that situation involving Mr. Porter, we actually started to follow him to Washington County Commissioners' public meetings to videotape what would happen, and what I saw was truly shocking. You'll remember, if you've seen the previous videos, Mr. Porter, he would walk in, they would say, "Mr. Porter, we're advising you to leave. You have an order of no trespassing," all of these things, and you need to leave. And when he would not, they would basically take a recess or even adjourn the meeting to try to get him out of there, and they would use the Washington County Sheriff's Office as their foot soldiers to try to get him to leave the building. Now, usually what would end up happening is that Mr. Porter would wind up leaving the public building based on the fear or the possible repercussions of being arrested for not leaving. We always knew that the Sheriff's Office were giving him an unlawful directive. They were following unlawful orders on the behest of the Washington County government. But now the Open Meetings Compliance Board for the state of Maryland has officially weighed in on this subject matter. And guys, you are going to want to hear every bit of this. So to briefly summarize, the Open Meetings Compliance Board ruled in favor of Mr. Porter and against the Washington County government, ruling that it was a deprivation of Mr. Porter's civil rights to ban him for 6 months from attending an open meeting. Guys, it was a absolute repudiation of the claims that Washington County set forth, and we knew it from day one. I knew it. Mr. Porter knew it. It was the reason we brought you the stories at the time. We knew how bad it was. We knew it was unlawful 4 months ago, 3 months ago, 6 months ago. From the beginning, we knew how bad this situation really was. Now, Mr. Porter made one key essential claim in his complaint, and that was that the 6-month ban that they were placing on him from being able to attend the meeting was in fact unlawful and did violate the Open Meetings Act for the state of Maryland. Mr. Porter, in his complaint, cited that what he was doing was protected First Amendment opinion, it was political in nature, and that the actions being taken were unlawful because they were essentially just trying to use prior restraint to get him to stop speaking. Now, in response to this, the Washington County attorney, Zach Kiefer, was the person who replied to Mr. Porter's complaint, and he argued that Mr. Porter's actions amounted to a public safety concern and that they were not violating his ability to view the meeting because he could watch the meeting online because they live streamed it. However, those arguments all fell apart within this July 17th opinion rendered by the Maryland Open Meetings Compliance Board. Now, here is why the board found in favor of Mr. Porter. Number one, the plain language of the act. The act states that a public body may, quote, remove an individual if their behavior is, quote, disrupting an open session. The board emphasized the words remove. meaning to change the location for someone already present, and is disrupting. This means the act authorizes removal only when the person is currently disrupting that specific meeting. This is not to be confused with any public meeting in the future. This is only for a specific public meeting if that person is creating a disruption at that particular time. The Open Meetings Compliance Board was fully in line with Mr. Porter's original assertion that you cannot prospectively ban someone from the future. This is something that was stated repeatedly over and over and over again and seemingly understood by nobody. If somebody is disrupting a meeting, you can remove them from that meeting. You cannot project that into the future. The board also found that alternate observation of the meetings was not enough to satisfy the Open Meetings Act. So that claim of Mr. Porter can just watch our public meetings live on the internet, that was not justified. They ruled that if a public body has a public meeting and there is plentiful of seats for that person to attend and be there and sit in the gallery of the public meeting, and if there is room for that person, they cannot prohibit that person from attending. They actually cited an opinion where there was an instance where somebody was not allowed to go into the meeting, but instead an overflow room because of how packed that meeting was. That if you have to put somebody in an overflow room, well, that is justifiable and that is allowable. But in this case, the Washington County Board had plenty of seats open, but yet they chose not to allow Mr. Porter to sit in one of those seats to attend this public meeting and to be part of the government process. They found that that was not okay, and that trying to justify it by saying he can watch the meetings on the internet was not lawful. And finally, the Compliance Board opinion would close out with the general assertion that Washington County has no power to prohibit future attendance. Therefore, the board concluded that Open Meetings Act simply does not authorize a public body to ban someone from attending future in-person meetings, even if they have been disruptive in the past. So with that, guys, just a stunning conclusion to a saga that has been so long and drawn out. This situation has been going on since March of this year, and it has just totally spiraled out of control. The Washington County government clearly overstepped their boundaries, and guys, it blows my mind that their county attorney allowed them to get this deep into crap. What does this mean for Washington County government? Well, the first thing it means is that they violated the rights of a citizen. And they didn't just do it once, they didn't just do it twice, but they did it dozens of times, and they did it repeatedly. They did it knowingly, in my opinion. And guys, for the county attorney not to clearly understand and protect its clients, which in this case is the government, is honestly a complete failure of all the legal minds in Washington County who work for the Washington County government, who get paid their salaries by the taxpayers. They should have known this was coming, but yet they allowed this train wreck to run down the road at full steam ahead. They violated Mr. Porter's civil rights, and they completely put themselves behind the 8 ball for a major federal rights lawsuit. And guys, I can tell you right now, that is something that is in the works. Obviously, Mr. Porter is not going to let this go. He was violated so many times, and the disruption that was caused by this is honestly insurmountable. They made him appear to be somebody who was constantly breaking the law, somebody who was constantly in violation of trespassing, when in reality, Washington County government were actually the ones in violation of the law. They were actually the ones depriving somebody of their civil rights. And guys, they adjourned their meetings. They took recesses so many times. They disrupted government so many times by their actions of recessing and having everyone walk out into the hallway. I saw it with my own eyes so many times, guys, and I couldn't believe what I was witnessing every time I saw it. I said, what planet am I on where when somebody walks into a room, they tell everyone to recess? How it wasn't nationally syndicated news and or world news, I have no idea. But guys, it was so unlawful right from the very start. They have found to be violators of the law, and now Mr. Porter will be going after them so hard. But if that isn't bad enough, guys, get a load of this. Maryland law actually is going to require the Washington County Board of Commissioners to verbally address their constituents and advise them that they broke the law. So, guys, I kid you not, at the next Board of County Commissioners meeting for Washington County, one of the commissioners, hopefully John Barr, is going to have to read a statement to the public and put out on the record once and for all that they violated Mr. Porter's rights. They are going to have to swallow their pride and address their constituents by way of law, forced by law. And they are going to have to tell the public that they violated a resident of that community, they violated his civil rights, and they are going to have to explain how they did it and why they did it. We have been on this issue for a long time, so it's a great day, like I said at the outset, for free speech and for the First Amendment. We will keep you posted on what's happening next, but bottom line, it's a great set of news, and it's a big win for this channel. It's a big win for Mr. Porter. We covered it. We were going to get to the bottom of this, and that's exactly what we did. We have final resolution on this matter. This is what attorney general's offices in the United States are supposed to do. They are supposed to make what is wrong right. And they did that in this instance. You do not want to miss future stories about this subject matter, but with that, we'll catch you guys very soon.